Well, first of all, thank you very much for being here. Hello, hello. Well, my name is Federica. I am the coordinator of PRIMS. I'm based in Brussels. And today with me, there's Anna, Veronica, and Livia. I'll give them the floor to introduce themselves. Please, girls. Vero, you can start.
Okay. As you said, Anna, before, I'm Veronica. I'm originally from Buenos Aires, South America, and now I've been based in Madrid for the last 2 years.
Anna.
Hello, my name is Ana Blite. I'm also based in Madrid. I've been in Madrid for a year now, previously in Asia Pacific and previously, in Switzerland.
And hi, I'm Livia from Brazil, originally from Brazil and in Brazil now. Good to be with you all.
You can clearly see the difference of season by the fact that I'm wearing, long sleeves, and in your case, you look like summer. That's beautiful. Okay,
Yep.
well, I think we can start, first of all, with a introduction of our great speakers today. Today, we have with us Professor Isolde Gendreau. She is intellectual property professor at Law Faculty of the University of Montreal. She's an expert in IP rights, especially for artistic professions, and she also knows quite a lot about AI and digital solutions and the impact on copyright. We also have Nicholas Brockbank. You probably know him already. We now call him our lawyer. He's a lawyer at GLS Solutions, and he's actually the professional expertise behind the new contract template for PRIMS freelancers. I hope you all had the chance to have a look at the contract and even to use them, all the different templates that we have provided, and they are available on the website. Maybe we'll send you the link in the chat. And then there's also Damien Fan, AIC Conference Interpreters, EXCO member, vice president, who also happened to write a master thesis on exploring the rights and obligations in interpretation services through the lens of copyright law. We also had invited representatives from the EU Intellectual Property Rights Organization and from the World Intellectual Property Rights Organizations, but unfortunately they couldn't make it. But this is actually a great opportunity for us to see whether you find, these kind of webinars useful. And if so, we can definitely organize a second one as well. Well, first of all, thank you to our speakers. It's a great pleasure to have you here with us today on a Saturday. Thank you to the members as well. You're making some times for us, for PRIMS, and I think also for a very interesting topic, which is intellectual property rights for conference interpreters. I'll now give the floor to Professor Gendreau, who will start with, an introduction of the main topic, because I always wondered whether we can actually apply intellectual property right to conference interpreting, given that it's quite different from translation. We don't have a tangible outcome unless it is recorded. So what do we do? Professor Gendreau, you have the floor. Thank you very much.
Thank you very much. It's a real pleasure for me to be speaking in this webinar. I've always been interested in translation and interpretation. I suspect it's probably because I come from an officially bilingual country, and I've always thought that interpretation and translation are activities that can be very Canadian. However, I would say the most interesting tidbit for you is that in the very first International Copyright Convention, the issue that seems to have really spurred its making was the issue of translation, in that the Berne Convention of 1886, which is our main copyright convention, has not protected the reproduction right until 1971. So the first right that was really recognized was the translation right. So we can move on from there to see how this can be actually applied in various contexts. And to do so, I have to explain to you the fact that there exists in copyright law, and it's a real translation issue, there exists in copyright law two expressions to refer to this concept. The first one is based, from its English origin, because the first Copyright Act was in 1709 in England, and it was the term copyright. And there's always a debate with the term copyright as to whether it reflects the right to copy or the right in copies that are made by reproducing copies. So this is a bit of a debate, and what it highlights is that we are referring to a system that really protects copies, the fact of having made copies. It's very work-centered, copy-centered, whichever approach you take. And this will create a difference with the other expressions that we use to refer to copyright in the other languages. And since I have a public of translators, I must say I'd be extremely happy to know if there's a third way of expressing copyright. And it's the term which in English would be author's right, but in French we say droit d'auteur, and then in Italian it's diritto di autore, and in Spanish derecho de autor. So in many languages, the term that we use to refer to this system is a translation in that language of droit d'auteur, author's right. What this means is that it's more author-centric, and initially it has meant that we protect authors' economic rights. I mean, both systems, of course, are interested in the monetary aspects of the creative activity that is protected. But with the concept of authors' rights, we've seen the development of two notions that are relevant to your work as interpreters. The first one is that because we are focusing on authors in the 19th century and then later on 20th and now 21st, but really 19th century with the movement of Romanticism, people became aware that authors not only have economic rights to protect, but also more personal rights, more intellectual rights. And this has given rise to the concept of moral rights. Doesn't mean that we are better than others. No, it's not morality in that sense, but it's morality in the sense of protecting personal interests of authors. And within that concept of moral rights, you have different prerogatives. The two most important ones, and they're the most important because they're the ones featured in the International Berne Convention, are the right to one's name, which traditionally has been called the paternity right, but this is not politically correct. So increasingly, we call it an attribution right, the right to be identified as author of a work, to be identified under one's real name, under a pseudonym, or even the right to remain anonymous. So this is part of the right of attribution within moral rights. Then you also have the second component, which is the right of integrity, in the sense that an author creates a work and presents it to the world under a specific guise that the author has chosen. And if somebody tampers with this work, then it's seen as tampering with the author's creative personality and the way this author has chosen to express himself or herself. So this right of integrity is also very important. It is part of that concept of moral rights. Now, In the countries that have authors' rights systems, and these are mostly continental European countries and the colonies that these countries have had over the years. In these countries, you may have other prerogatives that may not be as, let's say, as relevant, perhaps, in your context. One is the right to disclose the work. This is a very particular situation. And the other one is the right to withdraw the work from the market if you, if suddenly the work that is out in the market no longer corresponds to the author's thoughts or beliefs. And the standard examples we use for that are books about history, books about philosophy, works where the subsequent findings of science or the subsequent thoughts of the author may have changed since the work was initially made. But these types of prerogatives are not in the International Convention. And usually people today associate moral rights with this right of attribution and the right of integrity. So this is when you are more author-centric. However, I have to say that with time and with globalization, this system of moral rights has also made its way into what we call the copyright countries. So you have copyright countries, you have authors' rights countries. And the copyright countries, sometimes, I mean, when we look at them, we see that they have reluctantly admitted the concept of moral rights in their legislative scheme. But basically, they will provide more, it will be more framed with different conditions than what you may see in the authors' rights countries. But it can still lead to very positive results. So this is one consequence of being in authors' rights countries. Another consequence, which is also very relevant to you, is that over the years, other creative groups have recognized that they also would like to have protection in the authors' rights or copyright system. However, in the authors' rights system, the reaction was, well, we cannot protect you through an author's rights because you're not authors. You are conveyors of works. You are auxiliaries of works. These are terms that we use, auxiliaries of the dissemination of works. And these would be traditionally three categories of entities or groups of persons. The first group, of course, are performers, which in French are called artistes interprètes, as you have interpreters. So the first group is performers, and they are the ones who are closest to what an author does in terms of creative activity. Then you have two other groups that have been extremely important in the dissemination of works, and especially in the dissemination of musical works, because this is a concept that has much arisen in the context of the music industry. And you will have the sound recording producers, whom we also call the phonogram producers, and you have broadcasters. So with these two categories of activities, you're not dealing with physical persons. Of course, you have people working in those systems, but the protection is sought because these groups, the sound recording producers and the broadcasters, invest in the making of sound recordings. And you can see how their protection has evolved over the years now that we have digital works, and especially streaming and all of that. And broadcasters also consider that, well, they have to set up broadcasting activities and they go online and so on. So they form a group. They are the core of this group of what we will call neighboring rights or related rights, because they are neighbors or they are related to copyright, author's rights, but they are at the same time different from what copyright author's rights may protect. What this normally means is that within that group, there will be fewer rights than for authors. The term of protection is essentially not as long, it's shorter, because it's not based on somebody's life. You know, copyright term is life plus 50 or life plus 70, or sometimes even life plus 100 in Mexico. So you have a term of protection which is basically calculated from the moment that the actual object which is protected, the object being the performer's performance, the making of a sound recording, and the broadcasting event, the term of protection will be calculated from that moment, which means that for performers, for example, there is a new performance that is protected each time that performer gives a performance. So or makes a recording. So if you are a performer recording in 1990, then it will be, let's say, 50 years from 1990, and the same singer, people like in Canada like to take the example of Céline Dion. Well, when she was young, it's 50 years from her first rendition of a song. And well, when she sings in the Olympic Games, well, it's 50 years from this year. So the rights last for a shorter period of time, and they have fewer components than for performers. So this brings me to you, the interpreters, because interpreters can actually wear two hats. They can, and this is perfectly accepted. You can wear the hat of an author because what you do is a work. When you make a translation is and has always been considered a legitimate work in itself. And you may also be performing the work because you are saying it at the same time. So if we take the example of, let's say, a musician, a jazz musician, that musician, as he or she is giving the performance, can also be composing the work. And we will therefore have two types of objects to be protected, the work and the performance, and each is protected according to its own system. The translation, the work translation is protected as a work, and the rendition by the performer or the interpreter is protected as a performance under the scheme of these related or neighboring rights. So this is the general background that comes with what you do as interpreters. I think I should add something that is also important, and that stems from, again, from this distinction between the copyright system and the author's rights system. In the copyright system, there has traditionally been, and I think it will always continue to be like that, an emphasis on having a work in a copy, work that exists because it is fixed in a medium. Now, that medium need not be eternal, and you may print a book which is afterwards burned, but it's nevertheless been printed, and we have a copy of that novel. But in the author's rights system, there's less emphasis on this need to identify a fixation of the work. Fixation is the term we use for that very first time that a work appears in a particular medium. So in the author's rights system, it's much easier to accept that a work is not fixed in a medium. And examples we can have, for instance, are fireworks, long parades, for instance, and events that happen during the parade. These are activities where you see that people are being creative, they're seeking some sort of creative rendition, but to protect them without referring to a fixation in a particular medium is much easier in an author's rights country than in a copyright country. Of course, today, we can see that this fixation requirement has perhaps as its core function the need to have an example of the work, so that if you want to use the work, if you want to make contracts on it, if you want to sue because somebody is infringing your work, then you have evidence of this work. It's much easier if you have a copy somewhere than if it's something which is ephemeral. However, the definition of what is a fixation over the years has evolved, and we accept digital recordings as forms of fixation. And we know that digital recordings can last for a long time, but they can also last for a very short period of time. So this concept of fixation nowadays, I would say, has become less rigid than initially when we were talking about printing and having physical copies, like sound recordings that are in the form of LPs or CDs. So this is important for you because when you are interpreting, if there is recording, well, you immediately can say that the interpretation that you do is a work that is fixed in that recording as a work protected by copyright. And you also have a fixation of your performance as an interpreter. Performers is to recognize that they have the right to fix the performance. So when your interpretation is being recorded, this is for you to say, well, it's part of my right as a performer, as an interpreter, to allow this recording, because this system of performers' rights recognizes that you are a performer as an interpreter, even if it is not fixed. But of course, life is going to be easier if it's fixed. But this fixation is something that you as interpreter have the right to control. So I would say this is pretty much the very basic system with which we work. And nowadays, well, we have, of course, that training of AI, where you may say that you have reproductions, and you have reproductions of your works, your interpretation, which could be transcribed, which could be put on paper, just like any translation that is being done. And you also have the issue of copying your rendition as an interpreter. There's something else, though, that I believe should be mentioned, and it's the idea of the protection of your voice. The copyright scheme, and copyright in the big sense, copyright including both authors' rights protection and protection as performers, protection as sound recorders. And don't forget that when they are recording your interpretation, this is also a sound recording. A recording is not just a sound recording of music. It's also a sound recording of voices, like audible books, what they produce when they have audible books, when you have actors, actresses, like, I don't know if Maggie Smith recorded books, but they are also acting as performers and it's being recorded. So this is part of, this can be included in a copyright system, but you also have outside of that system, you have personality rights. And this is something also that has evolved starting in the 19th century and then over 20th century and so on. And initially, this personality right, actually the moral rights are identified as the very first personality rights that were recognized by law, by case law. But then you also have the big one, which is the right over one's image, your face. But normally, this is not the one you're concerned with. But this right of this personality right for a long time has really been linked to the right over one's image. And it's only, I would say, recently that we've also included in that concept of personality the voice, the protection of a person's voice. And this is not related to copyright or anything of that sort. It's just a personality right. And here we have, again, some distinctions that can be made that people have to accommodate. Personality rights are seen as parts of rights over one's privacy. So they're, if you use your picture, if somebody uses your picture without your authorization, this may be because they're violating your right as a person and to be used, and you have a right to be in your own private sphere. But over the years, this right of privacy has split, and especially in the US, this is very well done, where you have both this right of privacy, US style, or privacy, UK style, and the right of publicity. And the use of one's picture, image, the use of one's voice can be part of right of publicity. And this makes it, I would say, intellectually clearer than in countries where this right over one's image and the right over one's voice remain theoretically within the realm of rights of privacy. So the right over the use of your voice is something which is not strictly limited to what exists in the various copyright schemes, but you may also have this right, which may depend on the countries where you are working. I'm not sure that the right over one's voice is recognized everywhere. The first personality right that would be recognized as the right over one's face, one's body.
Thank you, Professor Gendron. I think this is actually very interesting when we talk about the rights, of our voice and the relationship with, defining ourselves as performers, as artists, as interpreters, also in the French meaning. So, and I think it links very well with what I'm about to ask Nicholas. So we talked about fixed and unfixed, work. So whether it is recorded or not, how can we protect our performance and our work from a legal perspective? What can we as freelance interpreters do?
Certainly. And firstly, thank you, Professor. Like, I listen to and participate in a lot of legal webinars, and very few of them are that clear and that interesting. So that was fantastic. Thank you very much. That was a great introduction. Okay, so we're looking at protecting the kind of rights of interpreters, and in particular, freelance interpreters, and in particular, in a practical sense, how do you get protected? So a bit of context for my answer is the issues that you're going to deal with. The first issue is that you guys are all performing and operating in a huge variety of jurisdictions. And you may, perform in one jurisdiction more than others, but typically you're all flying around and performing in different jurisdictions every other week. The problem with that is that there isn't a global law. So for one, you might have protections in one area which you don't have in another, is the first problem. The second problem is the cost of working out what your rights are therefore very high because it's different for each country you're in. And when we're talking about costs, the other issue is that your fees as freelance interpreters are very high as kind of service provider fees, but ultimately they're quite low compared to the cost of going to court and litigating someone. So very rarely are you going to be in a position where a crime against your intellectual property is going to be worthwhile going to court and incurring the costs and the time of going to court to kind of correct that crime, or that breach of your rights. So, given that this is your starting point, is there any good news? First thing is that there is pretty good news. And that news is that despite however many bad experiences we've had, people tend not to actually be criminal or trying to willfully act in a way to screw over their interpreters. What typically goes wrong is a lack of understanding of who has what rights and where permissions begin and end. So a big step that you can take to protect yourself is the mere act of clarifying exactly what it is you are and are not selling whenever you sign up a new client for a service that you're providing. What you'll find is that doesn't necessarily guarantee that no one ever illegally steals your intellectual property, but it will clarify, it will avoid 90% of the issues that ever arise, because as soon as people understand what they should be doing and what they aren't allowed to do, they actually tend to behave fairly well. Like it's quite rare to come across a genuine bad actor in commercial, whether it's for interpreting or for, frankly, in any commercial contract. It's very rare to actually have a genuine Machiavellian kind of bad guy. It's typically misunderstanding, lack of, and mistakes. That's what kind of goes wrong. So that's the first point. The second point is, whilst every country has their own laws and their own approaches to contracting and their own approaches to intellectual property, there are some general trends that apply almost universally. Maybe not completely universally, but almost universally. And one of those important trends is that most countries will allow adults and kind of commercial actors to agree contracts for pretty much anything that they want to agree, like subject to, you can't agree to commit a crime, you can't agree to do things that, breach health and safety, whatever. But genuinely, courts and governments will let commercial actors agree whatever they want to agree in a contract, and then they will uphold what was the intention of the parties when they signed that contract. The reason that this is important is that in your new templates, you've now got a situation where you can expressly set out what it is that you are selling to your customer. And if you haven't expressly written that in the contract, then the assumption is that hasn't been sold to the customer. i.e., you've got a clear statement about what exactly has been and has not been agreed with the customer. So one, the customer understands what they're allowed to do. And two, if you did ever go to a court or some sort of enforcement, they would understand exactly what you had agreed and they would enforce that. The reason that's important is that it means you can avoid getting sucked down the rabbit hole of interpretation of what intellectual property rights apply in your particular country and whether or not they were implied and given away, etc. I guess what I'm stumbling around is that there's a certain poetic beauty to the fact that the way that you solve your problems as interpreters under AIC is that you communicate clearly to the customer what it is that you are and aren't selling. Like clear communication is the solution to your problem about being service providers and having your intellectual property sold. So
it's also what we do as interpreters.
Sorry, interpreters. As interpreters, sorry. But
no, I mean, it's also what we do as interpreters. We also communicate clearly the message. So, it comes quite
exactly.
handy.
Exactly. That's the kind of poetic beauty of your kind of contractual solution to this problem. Now, the way that manifests itself in the new contract is that you've effectively got a box which says, these are the things that I'm selling you in terms of intellectual property. And then there's a list of things that say, these are the things that you're not allowed to do with intellectual property that I sell you. Now, you don't need to get dragged into debates about exactly what kind of intellectual property, like it don't have to have an academic breakdown of what you're selling. You just need to say, my voice can be recorded, or it can't be recorded. My image can be broadcast, or it can't be broadcast. But it's setting out what's allowed to be done. And if the customer wants something specific from you, you can then negotiate that and decide whether or not there's a price that needs to be paid for the thing that they want. This, I think, is quite a big step from what existed previously, where a lot of the relationships between the interpreters and the customers were implied, and neither party really knew exactly what was the deliverable being delivered from the service provider to the customer. Not sure if I need to go any further than that, but that's my summary of how contractual rights can save a lot of the headache that you're potentially going to deal with.
Thank you. And I think it's very good that you also mentioned, the clause in the contract. So we don't need to do that. I think, Anna, you shared the link. So that's very useful for our members. Damien, Anna, we can't hear you though. Anna, we can't hear you. No. Okay, maybe we'll give now. Yes.
Yeah. Okay.
Please.
So the link is now on the chat. Please don't forget to log in. We're very thankful to Nicholas, and this is really on behalf of all the association. This was a long-standing item on our to-do list, and thanks to your help, now we have an outstanding template. So please, this is also why you want to be an AIC member. So it's for members only. You can find it on the link that you'll find on the chat. And also, this is just a kind reminder to all the regions represented here. If you like the contracts to be translated into your local languages, you can follow the example of the Brazil region, who are extremely proactive and have already provided a translation into Brazilian Portuguese. It's posted on AIC's main website. And then also do not forget, though, that for translations, this is a live document that is updated regularly. So only the English version will be updated from our side, from PRIMS side. Thank you, Nick, again. Thank you for your help.
It's a pleasure.
Thank you. Damien, so we had the main background info from Professor Gendron, and then we went into the more legal aspects, and I'll give you the floor because you've researched. It's it's very interesting. We had the opportunity skim through it and to read the document that you sent us. You have several case studies that you also mentioned. One of those is the Dow Jones precedent, for example. So I'll give you the floor to, tell us more about your research.
Thank you, Federica, and hi everyone. It's a pleasure to be here today, although it's quite late here in Taipei already. I like to shift the focus to a very specific legal concept that has significant implications for interpreters, and that is the purpose of transfer doctrine. It's actually a German concept. I'm going to try and attempt to pronounce this very long German word. Bear with me. It's Zweckübertragungslehre. So the purpose of transfer doctrine is a principle from the German copyright law. And although there is no simple equivalent doctrine in the common law system, there is the principle of narrow interpretation of rights granted. So this principle is often applied in contract law as well as intellectual property rights, such as copyright and patents. This principle is relevant to disputes arising from clients wanting to make recordings of a conference interpreter's live interpretation. And let me explain why. Well, first of all, when a client hires a conference interpreter, there is an implied license granting them the right to benefit from the live interpretation. However, this license doesn't automatically extend to making recordings of the interpretation, because the original intent behind the agreement between the client and the interpreter is actually to facilitate real-time communication during the conference, not to create a permanent record of the interpretation. So when we apply the doctrine, courts might take a narrow view of the rights granted to the client. They might rule that making a recording without explicit permission exceeds the scope of the implied license and therefore infringes on the interpreter's copyright in their performance. And Professor Gendron mentioned moral rights. In some jurisdictions, interpreters may have moral rights that protect their reputation and the integrity of their work. Unauthorized recordings could potentially violate these moral rights. We know that sometimes recordings might be edited, and when such editing happens, it is very likely that our interpretations might be distorted. And even if we don't own the copyright in their underlying content, there is a potential violation of these moral rights. Now, in some cases, the client might argue that making a recording falls under fair use, especially if it's for personal or educational purposes, or even sometimes they claim it's just for documentation purposes. However, this is a very complex legal doctrine, and the outcome would depend on the specific fact of the case. So that comes back to why Nicholas said that making sure that these terms are very explicitly stated in our contracts are very, very important. So if the contract explicitly prohibits recordings, then it strengthens our position in any dispute. So to better understand how the purpose transfer doctrine applies to interpreters, I'm going to reference a case 20 years ago involving the Dow Jones Company. In a 2003 ruling, the Beijing First Immediate People's Court ordered Dow Jones and Company to pay a Chinese calligrapher, Professor Guan Dongsheng, $49,000 and issue a public apology for unauthorized use of calligraphy. So Professor Guan, he created the character Dao, which is the first character for the translation of Dow Jones. This calligraphy work was a gift for Dow Jones president in 1994. Now, in 2002, Professor Guan discovered that Dow Jones had used the artwork commercially without his consent on websites, ads, and other materials. So, of course, Dow Jones would claim that they had permission, but the court found no written agreement granting commercial use. So they ruled that the company only had rights to exhibit the original artwork. The court awarded damages under China's copyright law, and although Professor Guan also claimed for moral damages, but he was denied due to lack of evidence. The court emphasized that copyright remains with the creator unless otherwise specified, even if the physical artwork has been transferred to Dow Jones. So for interpreters, this ruling is significant because it shows that interpretations like commissioned artwork are created for a specific purpose, namely delivering live interpretation to an audience at a particular time and place. So we can think of it this way: if you hire a musician to perform at your event, you wouldn't assume that you have the right to record and distribute their performance without their consent. So the same applies to our interpretations. Our live performances are valuable, and creating a recording extends beyond the original purpose of our service. So I think this doctrine can support us in situations where clients might want to record our interpretations without permission. It also reinforces that the implied license we grant them doesn't automatically include recording rights. But I would very much like to agree, or I would actually fully support Nicholas's suggestion that everything has to be written very clearly, explicitly in our contract. I'll end here first. Thank you.
Brilliant. Thank you very much, Damien. I think these examples, they're quite clear. And bottom line is that we have to, use a bulletproof contract so that, we are protected. Now, when we decided to organize this webinar, by the way, which is, in the framework of the International Translation Day, and the title of the International Translation Day is Celebrating and Protecting the Art of Translation. We were also talking about the impact of digitalization and AI. And I know, Damien, that you have mentioned in your research several techniques or strategies that some producers or clients have used, for example, audio watermarking or real-time monitoring systems. Can you tell us a bit more about this?
Sure, but because the thesis was written 20 years ago and there were no such things as RSI platforms, but it's very clear that with the rise of RSI platforms and other digital tools, it has become more and more difficult to protect our intellectual property. And so there are a few technologies that might help us monitor the unauthorized use of interpreting recordings. And one of them is called audio watermarking. So it's actually a very simple idea, but it's a very sophisticated technique or digital technique to protect and track audio content. So it involves embedding a hidden inaudible signal into the audio file. So this signal, which is the watermark, carries important identification information such as ownership details, unique identifiers, or specific distribution rules. And it doesn't affect the quality of the audio. What makes audio watermarking particularly effective is that the signal remains invisible to the listener, but can be detected and traced using specialized software. So even if the audio is shared or altered, the embedded watermark can reveal who accessed or distributed the content. So this is actually a very powerful tool for right holders to monitor and control how their audio is used. It's widely used in the music industry, in film, in broadcasting to protect intellectual property. And media companies sometimes use watermarks to track the distribution of songs, commercials, or radio content. For example, watermarking has been used to solve real-time issues like the second screen problem, where users can access content on multiple devices. There's also recently an example from Korea's SM Entertainment. The company embeds specific noises. This is not the sophisticated technology that I just talked about. They're actually embedding specific noises into the music files of its artists. The noise would appear at certain intervals, like every 10 or 25 seconds. So these markers allow the company to track when there's a leak or where the leak originated. So if a version given to a TV station leaks, they can identify the source by the noise intervals. This is a very simple method, but it has proven to be very, very effective in tracing the origin of leaks in the entertainment industry. Now, of course, we could leverage this technology to monitor if and when our interpretations are recorded or shared without authorization. But the challenge is that the audio watermarking is fundamentally a tracking tool. So it does not prevent illegal recordings from happening. It only alerts us when our work actually has been used inappropriately. So I think the real challenge is still determining what actions we can take once unauthorized use has been detected. And fortunately, Nicholas just said that, these cases don't really, the litigation cases actually don't happen that often. So coming back to the rule of thumb is to make sure that we have that term in our contracts.
Definitely. And talking about unauthorized recording, I can just, mention one of the questions asked by a member. By the way, we'll now move slowly towards the Q&A session. One question was, what would be interpreters' alternative to deal or avoid unauthorized recording during distance interpreting, for example? And some examples are to charge a flat recording rate, embedded in the interpretation rate, or to use watermarking or other solutions. And I'll give the floor to Livia, who'd like to comment on that. Please, Livia.
Hi. Can you hear me?
Yes, we can.
Okay. I just got this message to unmute myself when I had already done it. But anyway, we've been discussing this since the pandemic when we all started working more frequently on platforms. What it is that we can do to avoid the hidden recording of our work. And one of the solutions that we came up with is to charge a flat rate, not the usual rate we charge, but a little bit more in any contract. And in case the client brings anything about it, we just tell them that we are charging a flat recording rate because there's no way that we can track that. We don't know when we are being recorded and when that recording is being used. And we don't even know if the recording is used for financial purposes or not. So it's almost impossible to track that, even though we have contracts which state intellectual property rights and the user recording, we still get recorded without being informed. So I wanted to bring this up and see if others have any suggestions other than charging a flat fee. I've been personally charging 10% more for recording in all of my events, just to make sure that I at least have a good rate, and I can, the interpreters are get paid for that.
Yeah, I think you have a little bit of an issue there, not really from a legal perspective, but more from a game theory perspective. That effectively, if you can charge 10% more for your services, then you should do that anyway. Like, presumably, you're all charging basically as much as you can charge for your services at any one time. So if you're adding an extra fee on top of that for recording, maybe for the first couple of times you do it, the customer says, sure, but eventually your total fee will reduce down by the same 10%. Do you know what I mean? Like if you might be recording for a flat fee for recording, sorry, charging a flat fee for recording, but the customer says, well, I don't really care. The total amount I'm going to pay is 100, and you can cut corners anywhere else, but I'm paying 100. So for me, the way your template is now set up is that if somebody is going to record, they need to write it into your kind of order form. And if they don't, the assumption is that they're not allowed to record. Genuinely, very few people will like do hidden recordings. Like it's very unusual for a commercial person to try to sneak a recording in, particularly if you've already had a discussion, are you recording, are you not?
It's not.
But I don't think it's impossible, but it generally
It happens all the time, actually.
Like a hidden recording.
Yeah,
because I mean,
it happens all the time.
Okay, well, for me, the other practical solution for this is that I think it probably wouldn't be a terrible thing for IEEC to have a register of bad actors. So the reality is that if somebody does genuinely steal from you or kind of mess you around because you've agreed that they weren't going to record and now they've recorded, the solutions that you'll have is get a lawyer friend to write a strongly worded letter asking them to pay you some more money, and hopefully they will. But if they don't, you probably won't go to court to force them because it costs too much to go to court. So you're probably not going to be able to solve the problem that had happened, but at least you can stop the problem happening to you again. And for me, probably the best way to doing it is by having a record on IEEC saying, these are all the conference promoters who are cheating us, doing badly, be careful about them. If you're going to work for them, make sure that they pay you more, etc. I genuinely think that might be one of the only ways you can practically avoid the situation of hidden recordings, because if somebody is intending to act in a way that's defined as willful misconduct, then I don't think there's much you're going to be able to do to stop them.
May I add something?
Please, Professor Gendreau, please.
We have a system here of small claims courts. And what we see is increasingly authors who find it too expensive to go to court. And I totally agree with what Nicholas Brocklebank has said. The fact that they have this possibility to go to a small claims court system empowers them. And usually, they're shorter procedure. It's not complex. It's meant to help people precisely in situations where they feel that nothing can really work. So if you have a small claims system in the countries where you are working, I would recommend to investigate the extent to which this can be helpful. Of course, it means that there can be delays and so on, but I can imagine that just for a conference organizer to receive documents about going to small claims, they're not going to like that, and they might offer to settle immediately. This is one thing to check. What we have also, which is very useful for authors and performers, interpreters in your case, we have what we call statutory damages, so that you don't have to prove how much damage you have suffered financially, but the court can decide, within a certain range, how much it can allow for damages. And if you have that kind of system, that can be useful. I'm not sure that this one is as prevalent as having a small claims court system, but when combined, we've seen some interesting results. Even large corporations use this statutory damage system very efficiently, not through small claims though, But in a small claim system, this can also prove to be useful.
Thank you,
So-
Professor. This is definitely food for thought. We'll we'll take note of that. These are all very useful suggestions. I see that Naomi has a question, and then I'll give the floor to Veronica. Please, Naomi, if you can also briefly introduce yourself. Thank you.
Yes. So Naomi Shankar, interpreter from Israel. I wanted to share actually a relatively recent experience. We had a court case, a big court case here in Israel that involved a legal team from the United States. There were quite a few court sessions over the course of several months. We had quite a large team of interpreters involved, and the client asked to record the interpreting. So we added a 25% fee for the recording that we requested and were paid. However, what I would like to highlight is a particular issue that hasn't been mentioned so far, and that is the issue of liability. Because oral interpreting will never be as accurate as a written translation that is done of, say, a transcript of the original session. In this case, both the original session in Hebrew was recorded and our interpreting. So when the client said that they wanted to record our interpreting, I specifically stipulated in the email where I gave our fee is that they will not be able to use that recording as any basis for a claim against us, because obviously it's not going to be as accurate as a full written translation. So that's also something to keep in mind and have in writing with the client.
Sure.
Definitely. Thank you very much, Naomi.
Actually,
please,
can I ask a
Nicholas.
question of are there IT systems that are most commonly used whenever you are doing remote or hybrid interpretations? So, for example, do you always use Zoom or do you always use Microsoft Teams?
There's many. I don't know if you
Yeah.
girls you want to answer. Yeah.
I would say it's Zoom most of the time, but there are many other platforms, including other platforms that are not meant for general use, platforms that are specifically designed for interpretation as well.
Yeah. The reason I ask is that in terms of protecting you from hidden recordings, Zoom, for example, will notify everyone on the call that a recording is being made. So you could insist on using only those platforms that give you that kind of recording warning, I guess, would be a good step in the right direction.
Yes, indeed. And talking about norms and now how to... I see that Victoria has a question. Please, Victoria.
Yes. Well, maybe the client has signed and paid an extra amount and so on, but that doesn't at all avoid one of the members of the audience to put his or her equipment, audio equipment around their telephone, the smartphone, and record the whole proceedings, and you are not aware of it.
True. But I think you are probably less risk than you might expect in that kind of a situation. What I mean by that is that if somebody is going to steal your intellectual property in a way to generate profit for themselves, like that's effectively the situation you're worried about. Like you don't really mind that somebody's just got to, privately is re-listening to the interpretation, so he knows what to do with like the WHO World Health Organization meeting minutes sort of thing. You're kind of worried about someone stealing your intellectual property, generating profit, or using it to train AI, something like that. And in those situations, I think you need basically a higher quality audio visual recording than can be achieved by someone like putting their phone in front of their computer screen. So what you've described is a real risk, but I think in practice, you're not really going to be in a much worse position than if they hadn't done that anyway.
Talking about norms, within AIC, we also work quite extensively with ISO. And I'll give the floor to Veronica, who will briefly tell us a bit more about ISO and intellectual property rights.
Oh, thank you, Fede. Just as a background, we thought it would be useful to include in this debate international standards. And for the benefit of our distinguished speakers, AIC was involved in the development of international standards on interpreting and interpreting related technology. AIC has contributed for many years experts and expertise. And I will show you, because we have a standard specific for conference interpreting, which is ISO 23155. And I will show you that there are at least 6 instances in which IP-related information is cited. The thing is that the IP that is cited is in terms of the confidential information that interpreters are liable to protect. So this is like introducing another angle to the conversation. It's not about protecting our own IP, but also that we have to be careful and protect the IP of our clients. So if you allow me, I will be very brief. I will share my screen. And then I would love to have the feedback from the speakers. You see, you can see my screen. The first clause that mentions confidentiality is clause 6, and we all know this, that we shall not disclose confidential information. By the way, every time you see a shall in an ISO standard, in an international standard, it means that it is mandatory. It is an obligation. Not even disclosing the information that is conveyed during the meeting, but also many times, and I would say all of the times, that meeting took place. We are not supposed to say that meeting took place. And I say this because there have been instances that, although the information that was conveyed during the meeting is not disclosed, you see posts of interpreters in a meeting or in a ministry or disclosing that meeting took place. And perhaps our clients don't want that to be known. That is the first clause that appears in the standard. The second one is that says that the CISP, which is the Conference Interpreting Service Provider, shall take all necessary measures to protect confidential information disclosed during the meeting and provide it to the interpreters in the run-up to and during the conference. And this is the very interesting one, that the CISP, the Conference Interpreting Service Provider, shall discuss the recording or webcasting of the interpreting with the client, if applicable, and adapt conference interpreters' fees as appropriate. Okay? So that is the second one. The third one is in cooperation of the head of team, provide instructions to conference interpreters concerning the handling of that confidential information, returning conference-related material to its owners in cooperation with the head of team. Then there is an annex, which is in the standard itself, which is an example of a code of conduct, which is AIC's. It's almost a copy of AIC's code of conduct. And the last one is this one also. It is an annex, which is informative in the standard, which means that it's not mandatory, but at least it's a recommendation of good practice. And it says that the content of the assignment agreement must or should, a recommendation, consider broadcasting, streaming, and recording of the interpreter's rendition and any copyright issues. So I will paste the link to the standard in the chat. It's accessible to AIC members only, but it's another tool that we can add to our IP-related toolkit. Okay, thank you.
Thank you, Vero. Whilst you put the link in the chat, I can, if you agree, I can start by reading one of the questions that were asked in advance by a colleague. Unless you're ready, you can do it. Are you ready? Done. Wow. Very easy. So Vero, I'll give you the floor to
It's okay. You can do it, no problem.
to ask the question. We have already answered one, so I would start with the second one. Can the scope of copyright?
Yes.
Okay.
So there are several questions, and I will try to combine them so that we don't have, because many refer to the same topics. So what would be interpreters' alternatives to deal or avoid unauthorized recording during distance interpreting? We have already dealt with that. If an interpreter is employed with an international organization, okay, their IPR belongs to the employer. The employer is the rights holder. But assuming that the third party has scraped an employer's website for the interpreter's interpretation and used it for its own commercial purposes, training, machine interpretation systems, etc., the employer, as the rights holder, is not interested in suing them. They are not in the business of translation and interpreting. So can the employed interpreter still sue, or I would say claim, okay, from the third party? That is a question for Nicholas.
Your sound, Nicholas.
We cannot hear you, Nicholas. I'm sorry.
So the answer goes back to what the professor was describing in relation to moral rights. So in short, in some countries, yes, in theory, you could, as the original author of the work, enforce some rights against this person. However, I genuinely think in practice, this might never be valuable enough for you to do it, or very rarely will it be. Because the kind of institutions that are scraping websites for data and reusing it are typically based in countries where it's very difficult to enforce your legal rights and may not even recognize the kind of moral rights as the professor described. So a comparable situation was one that my law firm faced, where basically a group of hackers in the border of Ukraine had set up a comparable website to my law firm's website to trick people into thinking that they were dealing with a law firm when they were dealing with a group of hackers. Now, that's illegal. We've got all the intellectual property rights in all of our logos and our designs, etc., all the moral rights in the world. However, it's very difficult to get a court to give you a decision and then get a police force in the borders of Ukraine to go and shut down a warehouse full of people doing something illegal. And they think the situation that you're describing, it'd probably be pretty comparable to that. If it was someone like, I don't know, maybe Google or Microsoft who's doing the scraping, then you're in basically means you're in a country which does recognize concepts like moral rights. You have a pretty good start. but yeah, in summary, it depends on what country you're talking about, and in practice, I think you save your time and save your effort and try and make some more money with a new client. Is basically my solution.
Okay, thank you. I have one for Professor Gendron. You gave the example of the firework, right, Professor? And there is a question that said that unfortunately it says anonymous. He or she asks, what is protected? The firework itself, or also exactly everything the artist does, what goes into it, how he composes it to produce it?
Yes, there's something which is not protected in copyright, and that's what we call ideas. Ideas and facts are not protected. What is protected is what is the particular way, particular form that is given by the creative act to this idea. So in the case of fireworks, we know that, well, I'm no expert in fireworks, but they set up their explosives in different ways. They have timers. There's a lot of work involved also when there's music to accompany it, because they want things to explode at the right time with the music and so on. So there's obviously a lot of planning that takes place in order to have fireworks. But I would say that the positioning of the various elements on the ground or wherever they use them, that in itself would not be protected by copyright. It's the rendition. I mean, it's what we see up in the sky, the fact that sometimes you do see it going up, sometimes you don't, but then it explodes. The color schemes that they choose. When they have music, you have you're protecting the fact that this explodes at a particular time. So this has obviously required effort and thinking and creativity on the part of those who have set up these fireworks. I would, if I were a firework producer, I don't know what particular name they have, I would definitely film my fireworks in order to fix these fireworks on a tape somewhere, analog or digital, so that if somebody reproduces the same fireworks, then there might be a basis on which to sue. It would be difficult in countries that really insist on having a fixation of the work. I'm not sure that there exists case law on fireworks. You make me want to look it up, because it would certainly be very interesting and a great example for exam questions, but we would have the result. But the fact is that it's very ephemeral, and just like a performer does, whether this performer is an actor, a dancer, or an interpreter, it's evanescent, but it's nevertheless protected. So it's it would be a fun case to work on, definitely.
Thank you. And a follow-up to that, because there is a comment that just got in the chat, is if ideas are not protected, I don't know if you are aware, perhaps you are not aware as lawyers of the the case by the Bickenwalls brothers against Mark Zuckerberg, and the movie Social Network about Facebook origins. Okay, are they claiming protection for ideas, original, or what is it that?
I don't know.
Wow.
I mean, I remember the movie, but I don't know anything about any activity around it.
It's a pretty good example about how this ends up actually getting resolved in real life. That the brothers made a claim and they made an enthusiastic argument that the law says X, and because the law says X, they're owed 100% of Facebook. And Mark Zuckerberg and Facebook said, no, we disagree. We think that you owed nothing. The law says Y, and therefore we don't owe you anything. However, the way that problem was resolved is that they decided it's too expensive and too difficult and too risky to go to court. So we'll make a payment to each other and not even resolve the question. We'll just all agree to disagree. And whatever the true answer is, we're going to settle it with a set payment and we'll move on with our lives. And frankly, that's typically how a lot of legal stuff gets resolved, that it's hypothetical arguments that there's no silver bullet, but you end up just resolving it as quickly as you can, which typically involves a specific payment, and then you move on.
And that's it. And there is no interpretation or resolution on the legal issue itself. Okay.
Yeah.
I have another question for the two of you that has to do with the scope of the copyright in an interpretation. How is to be redefined? Who defines the protectable scope of a copyright? Can I myself define the scope of what I license and not in a contract?
Yeah, so to speak to your new templates, the approach that's been taken is to use the broadest possible definition of intellectual property. So we don't want to get into a debate about what kind of IP was sold or not. Just any IP that you might have created in your performance of the services is stated to be your IP. And then there's a box that says, beyond my interpreting services, this is the IP that I agree to sell you. Okay. So, and so when you ask, can I define what I'm selling and not selling? Yes, it's exactly that. You're selling your service, and then if there's any extra license for any intellectual property, the customer needs to ask for it. You need to decide whether or not you're happy to sell it and what's the price for selling it. So you define it specifically in that box. And if it's not defined in the box, and sorry, earlier this evening, I actually slightly misspoke. Earlier this evening, I said in the box, you should define what is and isn't being sold. That's not quite correct. It's in the box, you define sold. And if it's not defined in that box, then it's not being sold and it's yours and there's no right to use it. That way, the default position when you use the templates is you're safe and you haven't given away stuff that you didn't intend to give away. Does that make sense?
Yes. Professor Gendron, okay, I don't see her. Irina, if you want to make a comment about this specific question in particular, you can take the floor. Otherwise, I will give you the floor later. Okay.
We still have 5 minutes to go, Vero, just for you to know.
It's a little bit about this. Can you hear me? Because I'm not with the directional mic.
Yes.
Can you hear me well?
We can.
Okay, that's very good. Yeah, this is a question about this particular topic because it's not specifically about interpretation, but it's about intellectual property that we create in the process of working for AIC, for example. And I wonder if I could ask an opportunistic question. We are developing, my workstream is developing a guidance tool for interpreters on how to discuss AI in a conference setting with the working title, The Decision Tree. Our goal is to make it available in different formats, including an online ink. From an IPR perspective, you would probably, Nicholas, classify it as a work for hire, and it will belong to AIC. Off the top of your head, do you think we need any additional protection to ensure that this tool is firmly established as AIC property?
So I would put this into that category of game theory and economic theory is actually more important than the legal theory here. Now, when someone says, how do we make sure that it's IE property? That's kind of assuming that your intellectual property is like a wallet full of cash. And if it's yours, then you have all of that cash. However, the reality is that lots of your IP is only worth something if somebody pays for it or some money or some outcome occurs from it. So in the case of your decision-making tree, that is definitely the IEC property, and you don't really have to worry about working particularly hard to confirm that it is the IEC property. It is your IEC property. For you, the real question is, how do you monetize that property? Now, the reality is nobody's going to copy the IEC decision-making tree and then go and sell it on Amazon, and like suddenly you find 100,000 units of decision-making tree have been sold for $5 each. For you, the way IEC members would benefit most from that decision-making tree is that as many people as possible in the industry know about and use that decision-making tree. So it is your intellectual property, and every time somebody else uses it, they've got a license to use it. And in theory, you could take away that license and stop them from using it. But the reality is what you're trying to do is you're trying to influence behavior. And so for me, I would get as many people to get it. And basically that means give it to them for free and spread it around as much as possible. That doesn't mean that it stops becoming IE property, but it means that you're getting the benefit from as much benefit from that product as possible.
Thank you, Veronica, for taking my question. Thank you, Nicholas.
No, my pleasure. And now the last question, in fact, is two that I will combine because they are about the same topic. One question has to do with a client recording my interpretation for, let's say, 20 days of interpreting a few years ago. And a year later, they use the recording to train, improve machine learning, okay? Which now interprets my meetings, their meetings instead of me. And that is related to another question that we were asked by Anonymous again. The question is there a fixed or any suggested percentage or a formula how to calculate our performance rights in monetary terms that your lawyers use?
So in terms of a formula to calculate your IP rights, no, there's not, is the short answer. It should be as much as you can convince someone to pay you. So my law firm, for example, we do run training sessions on various topics for customers. And if the customer wants to take a recording of that training session, it's effectively double the price. So we charge 100% markup for the recording rights. Now, for you guys, there's not really a shortcut way to work it out. Effectively, ask someone to pay you 100% or 400%, like as much as you can. And if they say no, lower the price until they say yes. That's effectively the way of working out what your IP should be. And what you'll probably find over a bit of time is that a bell curve of pricing ends up becoming like the norm, and you just need to kind of exchange that information between yourselves, and you'll kind of work out over time what is the average amount that can be charged. Does that answer that aspect of the question?
I think so,
then,
yes.
Yeah.
Yes.
And then,
yes.
It's fantastic. And then the other aspect of the question about somebody is, like misused my recording from 20 years ago. The professor actually answered that earlier, and that certain jurisdictions will go about giving you statutory payments to kind of make sure that the poor authors are protected. But the exact amount of that will change from country to country. Yeah.
Thank you very much. Shall we give the floor to Professor Gendreau and to Damien for final comments before we we close the meeting? Please, Professor Gendreau.
Yes, thank you. I'd say the problem is defining what is fair market value for this kind of recording. And it's about bargaining positions, and it's also about risk-taking. Many users of interpretations know that it's too expensive for interpreters to sue them, and they take advantage of that. That's very standard and classic in copyright law. Are you willing to pay legal fees to sue Google or any other like that? So, and they know it, So it's trying smaller measures is perhaps where you have the best positions. At the same time, I must say I'm happy to hear about the awareness of copyright issues for this profession, because it means that the discussions that we have today on AI and the training of AI reaches out to a lot more people than may imagine. And I think the only solution, if possible, we can have is to use the Belgian motto, l'union fait la force, Continue to be part of these discussions. I think it's important.
And that's probably why it is also important to be part of a professional organization, an association rather, like AIC. Please, Damien, I'll give you the floor. Thank you very much, Professor Gendreau.
Very briefly, I just want to thank both Nicholas and Professor Gendreau, and also PRIMS, for organizing this event. I think raising awareness is very important, especially among our own colleagues. I think someone mentioned in the chat box that a lot of the issue is that a lot of non-AIC members, or maybe even some of our own colleagues, they are not that aware of copyright issues, and they more or less get exploited, if you will. And so I think, PRIMS, you might want to organize another event. Thank you very much.
Thank you. Well, thank you very much to all of you, to the participants and the speakers. I think this has been a very interesting Saturday afternoon in my case, morning and evening in your case. The topic is indeed, quite delicate and difficult, but I think our speakers were all excellent, and I assume that my colleagues agree as well. You explained it it sounds so easy, it was actually very very easy to understand, from a layperson perspective. I think that's quite important. Girls, would you like to say anything else, or shall we say goodbye to our...
Thank you again. Thank you, right? Thank you to everyone. Thanks for coming. Thanks for being here on a Saturday. Thank you to our amazing speakers. It's always great to have real experts talking about what we do and giving us, founded and like data-based and information-based feedback. So thank you. It's extremely useful. It's very useful for all of us.
Well,
Thanks,
you
everyone. It was a pleasure.
Very
Thank you so
useful and
much.
lots of food for thought for future events and for future discussions with our clients.
Indeed. Well, you'll hear from us very, very soon, and this is for both the speakers and the members as well. So we wish you all a lovely rest of the day or the evening, and we'll see you very soon. Thank you very much.
Thank you, everyone. Bye.
Thank you.